Hello, my name is Trevor Orsinger, and today we are going to be talking about issues related to representing service members, the related laws, some of the policies, some of the benefits. By way of background, I am previously a staff judge advocate in the United States Air Force. I spent a number of years on active duty, and while I am in private practice currently, I do spend a lot of time on these particular issues. So with that in mind, let's talk about what the goal of this seminar is going to be. Military clients present unique legal needs, and they have unique legal options available to them by the very nature of their status as a service member. The course is designed to help the civilian practitioner better understand some of those needs, some of the available remedies, and also it's designed to help those who are prosecuting civil actions, against possible service members and some of the pitfalls that they need to watch out for. So with that in mind, I want to talk about some of the things we're going to cover over the next hour or so. We're going to discuss the client, the military member client, the unique needs that he or she may have. We're going to focus a lot on employment rights and employment benefits, and we're also going to discuss some housing related issues, some protections that may be available to the service member, as well as some benefit programs set forth by the United States government, as well as the state of Illinois. And then we're also going to talk about some general legal considerations for the service member as a client. In representing a military client, you do need to be very conscious of that person's background. According to the Department of Defense, there are approximately 1.2 million service members currently on active duty. Veterans Affairs indicates that there are about 20 million veterans in the United States, and 782,000 of whom live in the state of Illinois. Also be aware that National Guardsmen play a significant role in supplementing the active duty component of the Department of Defense. And there are approximately 13,000 National Guardsmen in the state of Illinois at any given time. Overall, when viewing the available remedies and laws and policies regarding representing service members, keep in mind that the laws are designed as a shield in most cases and not a sword. So these are defensive remedies as opposed to offensive remedies. Regarding the actual military client, keep in mind that most of them have probably deployed within the last 10 or 11 years. They may have unique psychological needs. They may not totally understand a lot of the laws available to them because there are so many. And so it is going to be up to you as the civilian practitioner to try and narrow and tailor their specific needs to that situation. Also keep in mind that these are clients that are high functioning. They're going to be able to work very, very hard for you and provide you very quick responses in most situations. They're great legal clients to have. When we talk about active duty service members, we are talking about those who are under Title 10 of the United States Code. Keep in mind that there are Title 10 soldiers and Title 32 soldiers. In a Title 10 status, those orders are signed by the President of the United States, and they are considered to be on active duty in service of the Department of Defense. There are certain rights and remedies attached to those orders. Most National Guardsmen, and those are going to be frequently your clients, are going to be serving in a Title 32 capacity. In a Title 32 capacity, they are serving a dual mission. They serve both the state of Illinois and the Department of Defense. Those orders are going to be signed by the governor of Illinois. Keep in mind that most remedies available under the laws we're going to discuss cover both Title 10 and Title 32 statuses. but there are some differences and there are some remedies that may be exclusive to one set of orders and not to the other. And we're going to talk about some of those differences in a few minutes. So let's begin by discussing employment law related issues and the service member. There is a federal law. It's the Uniformed Services Employment and Reemployment Rights Act, and that is a broad federal law that's designed to protect service members as they go forth and train for the National Guard or serve in an active duty capacity. Illinois has a law that supplements USERRA, and we're going to call it USERRA, so understand that that's for Uniformed Services Employment and Reemployment Rights Act. Illinois supplements this through the Illinois Service Members Employment Tenure Act. The purpose of USERRA is to encourage service members to provide service to their country, to the state of Illinois, without being penalized by their employer. And the statute lays out three very, very important points and policy provisions that talk about that. From a practical perspective, any employer is going to be subject to USERRA. It doesn't matter the size of the employer, the business that they're in, they're still going to be subject to the provisions that USERRA provide. So the provisions of USERRA are going to apply to any employer in the United States. It doesn't matter the size of their company, the size of their business, they're going to be subject to those laws. What may be different is whether or not the employee can enact or can claim those rights under USERRA. So the provisions of USERRA are going to apply to any employer regardless of the size. And the statute says that an employer is any person, institution, organization, or other entity that pays salary or wages for work performed or that has control over employment. Now, certain employees may not necessarily be covered by USERRA, but it is a very, very broad provision. Some issues to watch out for are seasonal employees and temporary employees. The statute doesn't get into the differences between statuses of employment, but understand that from a practical perspective, full-time employees are automatically going to be covered. Part-time employees are automatically going to be covered. Seasonal employees may or may not be covered, and temporary employees may or may not be covered. And that's going to be fact-specific, and that's going to depend on the situation at hand. Understand that folks who go out and engage in service under Title 10 are going to be protected, and those who engage in service under Title 32 are going to be protected. One status that is not necessarily going to be protected, and it's questionable, are those service members who are in a state active duty status. And that is performance in a very, very strict status that's for the state of Illinois only. Now, those orders are signed by the governor, and it's an issue of whether or not USERRA is going to protect them. Illinois recognizes that that gap may exist, and they've provided a supplemental law under the Illinois statutes to guarantee that those who have served in a state active duty status are going to be protected regardless of whether USERRA may or may not apply in that situation. But again, that's going to be fact specific, but it's something that you should watch out for. When an employer is going to engage in service, and it doesn't matter if they were ordered to service or if they volunteer for service, they're going to be well advised to provide as much advance written notice to their employer as possible. If circumstances don't allow for that, certain exceptions are obviously going to be made under USERRA, but it is wise for them to provide as much advance written notice as practicable. The Department of Labor has an outstanding website that talks about the 5 main requirements for employee service members to claim some action under USERRA. So let's talk about some of those 5 requirements. They obviously must have been absent from their civilian employment, and again, they need to provide as much notice as possible for that absence. And they should provide a copy of their written orders that are again going to be signed by either the President or the Governor. The cumulative period of military service cannot exceed 5 years. Anything beyond that 5-year period is not going to be necessarily covered under USERRA. So again, be conscious of that when you are engaging with your service member client. There could be various breaks. They could be deployed for 6 months, return to work, deployed again for 6 months, and then return to work. That cumulative period can't exceed 5 years. Another important requirement under USERRA is that the service member must have served honorably. That is to say that they they cannot have been subject to a court-martial where they received a less than honorable discharge characterization. Keep in mind, though, that it's not just courts-martial that are going to determine service characterizations. The Air Force, for example, and all of the other services have administrative remedies to separate service members. And so they can characterize that separation under many, many different types of service. But what is key is that the characterization could not have been punitive, and only punitive separation codes are given by a result of a court-martial. And this obviously is an important point. The person must have reported back to their employer after the period of military service is complete. Keep in mind that there are going to be certain time frames that the employee service member is going to have to abide by in order to successfully claim any redress under USERRA. And we're going to talk about some of those reporting requirements in a bit. Illinois has very, very similar provisions, especially for state active duty and for service to the state of Illinois. The overarching provisions of USERRA mandate that returning service members must be reemployed to the position that they held prior to their military service. This is known as the escalator principle. In other words, they are entitled to the same seniority, to the same position that they would have held had they not been deployed under those set of orders. They're entitled to the same status, to the same pay, and to the same benefits that seniority would have provided them had they been there prior to their, or had they been there without that military service. Keep in mind that vacation time may not necessarily be a right entitled to the service member employee. They can certainly use vacation before or after the deployment, but they are not necessarily entitled to accumulation of that time. So there's one benefit that they may not necessarily be entitled to. Concerning the time limits on USERRA, service members do have an affirmative obligation to provide notice to their employer that they are going to be returning to work. Those time limits are going to be dictated by how long they spent on orders, on deployment, in service of the National Guard, doing training, whatever the case may be. And again, this USERRA covers just about every conceivable circumstance for when a service member would be absent from work. If they were there for, if they were on orders for less than 31 days, they need to report back relatively quickly, by the end of the first regularly scheduled work period after the end of their duty time. Again, and USERRA's overarching philosophy is if things are impossible or very, very difficult to accomplish, there is a right of wiggle room, for lack of a better term, as far as how much notice they need to provide to their employer. If a service member is gone from 31 to 180 days, the employee must apply for reemployment no later than 14 days after completion of the military service. If they're gone from 181 days or more, they have to apply no less than 90 days after completion of military service. If the service member has a disability or injury as a result of being on those orders, they are given up to 2 years to apply for that reemployment, and that's to, from a policy perspective, to help them convalesce, to help them heal, but it's also, the idea is to maintain the integrity of their position despite those injuries. As far as health care and the pension program for a service member employee related to their employer, the employer still has to ensure that those programs are maintained for the service member despite being on those orders. USERRA goes into some detail on the mechanics of how this is broken down, but just be aware that those benefits are going to be, they're going to follow the service member employee, and that's something that you should be aware of when you're counseling your client. Relative to USERRA enforcement, in general, this is going to be, in general, most employers are going to be aware of some of these requirements. If you are counseling an employer on USERRA rights, especially a small business employer, make sure that they understand the enforcement provisions that are in effect. USERRA provides for some very, very significant remedies to a service member employee, and it's important that even the small business owner understand that they are still subject to the provisions of USERRA. The way this typically works is if an employee is not reemployed after coming off of those orders, after those orders have terminated, they can pursue certain remedies. And those remedies are spelled out in the statute. But overall, one very basic remedy is that they can file a complaint with the Secretary of Labor. The Secretary of Labor can provide technical assistance, they can investigate the claim, and they can issue notice of results concerning that investigation. That's important because if the Secretary of Labor is unable to resolve that USERRA claim, the Attorney General may then, under certain circumstances, step in and represent the service member employee in any pending matter. USERRA provides different remedies for different types of employer. And there's two types. There's the state employer, private employer, and they're going to fall into the same category. And then there's the federal employer. Let's talk for a few moments about enforcement under USERRA. And this is going to apply if your service member employee client is unable to successfully resolve the issue with the employer. And it's an important point to address because when dealing with especially small business employers, you're going to want to know what rights and remedies are available to the service member employee. Typically what will happen is that the employee service member always has the ability to file suit, and we'll talk about some of the mechanics of that in a moment. That's always going to be an available remedy to them. But typically what will happen is that the employee can file a complaint with the Secretary of Labor. The Secretary of Labor can then provide that employee with technical assistance, help investigate the claim, and they then issue a notice concerning the results of that investigation. And that notice is a very important point because it will help determine if the federal government can get involved relative to private employers and state employers and federal employers. There are two basic types of employers as far as USERRA is concerned. There's the state private employer, and then there's the federal employer. And the state treats, the USERRA treats the state employer identically to a private employer. And that's going to be an important point when traveling down this road with your service member client. So let's talk about the enforcement rights that are available to the employee under a state employer or private employer situation. The Attorney General can potentially provide representation to the employee if the notice issued by the Department of Labor, the Secretary of Labor, determines that there is actually a potential USERRA violation. The Attorney General can then get involved relative to litigating that claim. Take a look at the statute for how that process actually works and how the notice is going to be an important part of the enforcement provision. That said, the employee of a state or private employer can always file suit in district court, and they can file suit for enforcement of those remedies and rehiring into the position that they enjoyed before their deployment. When pursuing action against a federal employer, there are more limited rights for the employee service member. And specifically, they have to go through the Merit System Protection Board in order to seek enforcement of the provision. They can directly proceed to the MSPB without having to wait for the Department of Labor's issuing of that notice, however. But it's strictly limited to MSPB and not district court. As far as damages and enforcement go, there are wider remedies available against the state and private employer. And that probably makes some sense because I think USERRA contemplates that the federal government is going to be more cognizant of these issues, and they hold them to a higher degree of responsibility in actually providing employment back to the service member after completion of their orders. So when looking at the state and private employer, there are certain damages that are going to be available to the service member employee. Obviously, one of them is going to be obviously, one of the remedies that's going to be available is putting the employee back into that position that they enjoyed before they deployed. They can also seek lost wages and benefits. And for willful conduct, there are liquidated damages available to the employee service member. The statute specifically says that the state is subject to the same remedies as may be imposed on a private employer. And that's a pretty significant point. Again, it's the statute and Congress holding the states up to the exact same standard as a private employer. An important point to remember is that there are no filing fees when pursuing action against a state or private employer. When trying to seek enforcement against a federal employer, and this is going to be a very, very unique circumstance. Again, the federal government should be conscious of their ability and their duty to put the service member employed back into the position that they enjoyed prior to their deployment or prior to the period of their orders. The MSPB is the route to seek redress for the service member employee. The damages, though, are going to be limited to compliance, that is, reinstating the employer back into the position that they enjoyed, lost wages, attorney's fees, expert witness fees, and other litigation fees. What is not addressed here are damages for willful conduct. And that is something that you are not going to be able to seek. Those liquidated damages that you would against a private employer or a state employer, those are not available for federal employers. Some general provisions to think about as you counsel the service member employee are that there are no statute of limitations to when an action can be filed against an employer. And this goes to the concept that USERRA is a shield rather than a sword. Congress does not want to impose restrictions on when a service member can try and assert these claims for reemployment, given the unique nature of their service, the types of orders that they're on, and other factors that may exist as a result of their military service. USERRA provides for very, very broad subpoena power by the Secretary of Labor. And that makes sense because the Secretary wants to try and resolve these at a minimum level without having to engage in extensive litigation. The Department of Labor has an outstanding website in helping vets and those who are returning from National Guard duty to help them gain reemployment with their employer. Department of Labor, to give you an idea of where how effective the enforcement by the Department of Labor is that in fiscal year 2011, 90% of the claims that were filed were resolved by the Department of Labor within 90 days. So it's a very, very effective program. The Department of Labor is also required to report to Congress how many claims were filed in a given fiscal year. In 2011, there were approximately 1,500, I think it was 1,548 new claims made to the Department of Labor. So from a practical perspective, the enforcement through litigation, whether that's in district court or through the Merit System Protection Board, is going to be a last resort. And that's probably why the damages are going to be as extensive as they are for state and private employers. It's a last resort. Truly, it is a shield for the service member to obtain reemployment. Illinois has supplemented USERRA for some very, very specific courses of action that may not have been addressed under the USERRA provisions. And that's the Illinois Service Members Employment Tenure Act. Contains many provisions that are similar to USERRA, but it also contains a provision for those who may be serving in a state active duty status. And while there are many, many, many programs available that discuss the differences between Title 10 and Title 32, state active duty is typically a very unique set of orders for a unique circumstance. A lot of times that's going to be, for example, a situation where there is a state emergency, but the federal government has not contributed any funds to assist in that recovery or to assist in that in the mission to resolve, whether it's a state flood or some other natural disaster that may be, quite frankly, not large enough for the federal government to provide funds for. And in the Service Members Employment Tenure Act, you'll see that they specifically, the Illinois legislature, specifically addressed USERRA and notes that USERRA doesn't cover those who are in state active duty service. I'm not entirely sure that that's realistic. I think USERRA may make some provisions, may make some remedy available for those who are in the state active duty service, but to eliminate any doubt, the Illinois legislature specifically made this apply to state active duty service. The other area that it specifically covers are offers of employment. Now again, USERRA may cover that, but to avoid any ambiguity, the Illinois legislature said if there's an offer of employment and you are called to service after that offer, that position is still going to be protected and you're going to be entitled to employment under that offer. I would encourage you to explore that statute and the Illinois legislature's intent in providing very narrow guidance on those two specific subjects. If an employer in Illinois is found to be in violation of the Service Members Employment Tenure Act. A knowing violation is going to incur a $5,000 penalty. There's going to be injunctive relief available. There are no fees. But most importantly, they're going to be placed on the Illinois Attorney General's employer list, which indicates, those employers who have been less than helpful to returning service members after certain orders are met. Whether that's through a deployment, through training, and through even state active duty. Illinois also offers some other protections to service members, and again, they're designed to supplement USERRA, not necessarily override it, and in fact they can't under the USERRA statute. I've posted a list of the available and applicable laws of Illinois. I encourage you to explore these and just be aware of them. Of particular note is the Family Military Leave Act. That allows family members to take an unpaid leave of absence for a limited amount of time, between 15 and 30 days, depending on the length of the orders, to spend with either the departing service member or the returning service member. So be aware that that's also available to family members of service members. Some additional employment considerations that may be available to service members and veterans are something that you should also be aware of when counseling your clients, and whether that's the service member or the employer. The service member is entitled to veterans preference both in the federal government hiring system and the state of Illinois. But in 2011, Congress passed the Vow to Hire Heroes Act, and that provides some tax credits to employers. Illinois also offers a tax credit. So in counseling some of these small businesses, make sure that they're aware of some of the benefits to hiring veterans and some of the tax credits that are available to them. Veterans are also entitled to certain relief under the Service Members Civil Relief Act, and that's going to be one of the other major discussion points of this seminar. The Service Members Civil Relief Act, or SCRA, is designed to help veterans, help service members in a multitude of circumstances. We're going to discuss a couple of the specific points, especially those related to housing and to default judgments. But be aware that SCRA covers a substantial number of remedies available to service members. Under the Service Member Civil Relief Act, and that's at 50 U.S.C. 501 to 597, Congress has set forth a pretty specific policy, and that's to provide and strengthen the national defense by providing, again, shield-type provisions for the service member. And we're going to discuss a couple of those provisions now. SCRA is going to apply specifically to active duty service members under Title X, and it's also going to apply to National Guardsmen under Title 32. It's going to apply in training situations. It's going to apply if a service member has to deploy for a year. Keep in mind, though, that SCRA also makes the distinction between pre-service obligations and pre-service remedies versus those for when the service member is actually on orders and in service of the state or the federal government. In examining some of the housing protections that are available for service members, let's look at one of the most basic, which applies to leases that service members may enter into. One of the many benefits that SCRA provides to service members is the ability for that service member to terminate residential leases in certain situations. In order to do so, there are a couple of situations that a service member can be in order to terminate that lease. One of them is going to be entry into active duty. The other is going to be a permanent change of station or a deployment order. Now, under this particular provision under SICRA, the service member has to provide written notice to the landlord that they are entering into active duty or that they are engaging in a permanent change of station. And what that typically is that the service member will receive orders to go from one base to another, or deployment orders. They're going to need to provide those orders to the landlord. And the effective date, this is a very important point to assist service member clients with, and also landlords, is defined in SICRA, and it's the termination of the lease is effective 30 days after the first date on which the next rental payment is due and payable after the date on which the notice is delivered. So be careful on the timing aspect so you're not essentially paying 2 months rent as opposed to 1 month's rent. Again, you're going to want to review that provision and then appropriately counsel your client if that's what they need. Some of the other general protections related to residential leases is that a landlord can't engage in any self-help remedies, specifically prohibited under SICRA. And specifically, the landlord cannot evict a service member without a court order. Typically, that's going to be the case anyway, but the reason Congress put that in there is to avoid any self-help measure by the landlord. In dealing with foreclosures, the Service Member Civil Relief Act specifically addresses any rights and remedies available to foreclosures. What it does not do is provide general relief against mortgage defaults, but it is there to provide at least some buffer between the foreclosure process and the service member who is on some type of orders. An important point to remember under this provision is that this applies to pre-service mortgages only. It does not apply, for example, if a active duty service member takes out a mortgage and then subsequently goes through the default process. These are pre-service mortgages only. In dealing with these pre-service mortgage foreclosure matters, the court may grant a stay of enforcement of those orders. And SICRA specifically says, in an action filed during or within 9 months after a service member's period of military service to enforce an obligation described in subsection A, the court may, after a hearing and on its own motion, and shall, upon application by a service member, when the service member's ability to comply with the obligation is materially affected by military service, do one of two things. They can stay the proceedings for a period of time, quote, as justice and equity require, or they can adjust the obligation to preserve the interests of all the parties. Now, while this may not necessarily provide complete and total relief for the service member, it is designed to assist them in trying to remedy the foreclosure action. SICRA does prohibit specifically self-help foreclosures, and again, that's going to probably be the case in 99% of all foreclosure actions. But it assists a service member in ensuring that the process is done correctly. So there's no self-help foreclosure action without a court order. Now, there may not be specific law designed to assist service members who are underwater on a mortgage or find themselves unable to pay for a mortgage or seek some redress. But there are a lot of programs that are going to be available to the service member, whether that's through the federal government or through the state of Illinois. One of the key programs that you should be aware of in advising service members is under the U.S. Army Corps of Engineers Homeowners Assistance Program. And essentially what that does is that allows qualifying service members who have received orders to engage in a permanent change of station between February 1st, 2006 and September 30th, 2012 to obtain some assistance from the federal government for being underwater on their home. And essentially the big remedy is that the government can purchase the house on behalf of the service member. They can provide up to 90% of the difference between the fair market value at the time of purchase and the fair market value at the time of sale. And that can be, for some service members, a very, very significant advantage and assist them in avoiding bankruptcy or avoiding foreclosure action. Some of the specific requirements that the HAP program requires are, again, must have PCS orders. That's leaving one base and going to another base between February 1st, 2006 and September 30th, 2012. And the distance between those bases must exceed 50 miles. The service member must have purchased the property before July 1st, 2006. They must have used it as their primary residence. And this is a key provision, they must have suffered a decline of at least 10% in the value of the home from the date of the purchase to the date of the sale. Also, if counseling surviving spouses, this does apply to them and to certain wounded personnel. Some of the remedies available are going to be defined by, and I would encourage you to examine the Homeowners Assistance Program under the U.S. Army Corps of Engineers. Some of the remedies are going to be government-owned property. The government can assume the mortgage. They can assist on foreclosure actions. But the biggest one is that they will provide 90% of the difference between the sale and the purchase of that property. They'll also pay for certain closing costs, and it's an excellent program available to those who may not have any assistance otherwise. The Illinois Department of Veterans Affairs also publishes a list of programs that may be available to service members in the event that they're struggling with payment of their mortgage. Again, I would encourage you to take a look at some of those sites. If a service member client comes to you and is looking to determine what remedies may be available to them because they can't pay their mortgage. So those are going to be some of the policy guidance or policies and remedies available to the service member for mortgage issues. In returning to the Service Member Civil Relief Act, the other important point that I do want to touch upon in this seminar is the ability of the service member to seek assistance on default judgments. And again, SICRA provides a lot of different remedies for a lot of different situations. But we're going to talk about default judgments and stays of proceedings. In focusing on Section 521 of SICRA, I'm sure every attorney is aware that they must file an affidavit that the defendant in a certain cause of action is not in the military service or is in the military service. One of the resources that SICRA specifically defines in trying to determine whether the service or whether the defendant is in the military service is the Defense Manpower Data Center. That's available online, and that's a resource that you can check to determine if the defendant is in military service. If a defendant is in military service, a court cannot enter a default judgment until the court appoints an attorney to represent the defendant, and if an attorney cannot locate a defendant service member, the actions by the attorney shall not waive any defense of the service member or otherwise bind the service member. In SICRA actions, if an attorney is not able to ascertain whether the defendant service member is on military service or is on orders, they may be required to post a bond, and that's used to indemnify any action against the defendant in that situation. So in those situations, the attorney may be required to post a bond, and according to SICRA, that bond shall be available to indemnify the defendant against any loss or damage the defendant may suffer by reason of any judgment for the plaintiff against the defendant, should the judgment be set aside in whole or in part. And that bond is going to remain in effect until the expiration of the time for appeal and setting aside of a judgment under applicable federal or state law. In examining when the Service Member Civil Relief Act and default judgments can be vacated, SICRA also does provide some guidance for courts in how to handle those situations. And generally, the statute provides that if a default judgment is entered into an action covered by SICRA against a service member during the service member's period of military service, the court entering the judgment shall, upon application by or on behalf of the service member, reopen the judgment if two requirements are met. The service member was materially affected by reason of that military service, and the service member has a meritorious or legal defense to the action or some part of it. So keep those in mind if you're entering a default judgment on behalf of your client, or if you're seeking to vacate that judgment on behalf of a service member client. Along those same lines, the Service Member Civil Relief Act applies to situations that require a stay in proceedings. And in examining those situations, the statute divides actions with service members who have not received notice of the action with those who have received notice of the action, and treats those service members very differently, and with good reason. If a service member does not have notice of the action, and if the defendant is in military service, the court shall grant a stay of proceedings for a minimum period of 90 days if a defense exists that requires the service member defendant, or counsel has been unable to contact the defendant or otherwise determine if a meritorious defense exists. If a service member does have notice of that action and wants to stay these proceedings, they have to demonstrate that they were materially affected by their service in order for the stay to actually occur. There's a general provision in the Service Member Civil Relief Act that discusses generally stays and vacations of judgment, and that's under Section 204 of the statute. Something to be conscious of when you are representing a client who is a service member or representing a client who is prosecuting an element against a service member. The Service Member Civil Relief Act also has extraordinary benefits for matters related to installment contracts. It provides for certain income tax relief for members who are on orders or who are deployed. It provides guidance on handling life insurance and health insurance reinstatement. Concerning the life insurance, obviously the life insurance company cannot suspend or cut service based on the military member status. So again, it would be a statute that I would encourage you to explore, just to seek all the available options that may help your service member client. Illinois has also supplemented the Service Member Civil Relief Act, and they've done so through the Illinois Patriot Plan. And the Illinois legislature is focused on several important areas, one of which is that a service member or their spouse may cancel a cell phone contract in certain situations. And that's going to be found at it's Public Act 0940635. Again, it's going to have specific requirements, but in the event that your client service member, as a result of their military service, needs to cancel that plan, Illinois has provided a way for service members to do so. The other very, very important element to keep in mind is that no municipality or private utility provider can cancel natural gas and electric utilities as a result of the service member's service to the state of Illinois or the federal government. So keep that in mind when you're counseling your clients if they're in dire financial straits, that at a minimum the utilities will remain on, which, depending on how financially bad the situation is, could mean a lot to that service member. The other area that Illinois specifically addresses in the Patriot Plan is on life insurance. And again, take a look at that statute. They can't, an insurance company cannot terminate that policy based on the service member's service or orders. Another very, very helpful element to both the Illinois Patriot Plan and the Service Member Civil Relief Act is that there is a cap on the interest rates for, under SICRA, pre-service obligations. And that applies to anything. It's a situation that I've dealt with firsthand. I think a lot of employers, especially, I'm sorry, not employers, but a lot of credit card companies were not previously as sophisticated on as they are now. I do recall helping a family trying to explain to a credit card company, or it was an auto loan company, that there was a cap on the interest rate at 6%. That's automatic. That is without question capped at 6%. From a practical perspective, that may be difficult to implement and convince certain creditors that there is a cap on the interest rate. But in general, if you sit down and explain the situation with that creditor, they typically will resolve that situation, oftentimes to the satisfaction of the service member. So keep that in mind if your client is in financial straits, in dire straits, that one of the ways that they can potentially help themselves is by that cap on that interest rate. A very, very important point that may stop the bleeding, so to speak, with your client. And again, SICRA and the state of Illinois both have provisions that are directly on point and that limit that. So the situation is it's going to be situation specific. It may apply to only pre-service obligations, but again, that could help your client tremendously. Also be aware that there are automobile lease termination provisions under the Service Member Civil Relief Act. And that is a key provision, especially if somebody's going overseas. Keep in mind that you're going to get some resistance with some of the lenders, but keep at that and make sure that you have SICRA available and be aware of the enforcement processes. So again, we've talked about, as we're winding down this presentation, we've talked about some of the available remedies under state and federal law to the service member. We've talked about some of the tax credits, for example, that are going to be available to employers for hiring veterans. Keep in mind that both the federal government and the state of Illinois have very, very robust programs that are designed to help the service member. In Illinois, the Illinois Department of Veterans Affairs has a nearly 50-page handbook that describes all of the available programs and benefits available to veterans. Some of those examples, or some of those benefits are, the waiver of licenses, whether that's fishing license or hunting license. A lot of the waivers of those fees. There's a waiver of an education requirement to be hired by the Illinois State Police. Also be aware that there's the Illinois line of duty compensation. That provides a death gratuity for any service member who died in the line of duty, and currently for fiscal year 2012 that amount was over $329,000. There are tremendous educational benefits. There are bonuses available to service members for their service. There's burial benefits, and there's 4 veterans homes in the state of Illinois for elderly veterans. And the Illinois Department of Veterans Affairs maintains a very healthy and robust catalog of those options. So bear in mind that a lot of the provisions and a lot of the benefits that are prescribed by the state of Illinois and the federal government are designed to assist your client in making sure that their rights regarding employment are preserved, that certain elements concerning foreclosure actions, default judgments, stays of proceedings are available to service members as a result of their service. We spent some time today talking about the Uniformed Services Employment and Reemployment Rights Act, the Service Member Civil Relief Act, and the Illinois Supplemental Acts that are there to assist the service member. Keep in mind that you are going to have a client that is going to be ambitious, that's going to help you, that's going to be aware of the remedies and rights that are available to him, and it's up to you as the attorney to help narrow and tailor those needs or those remedies to that specific service member situation. I appreciate your time, and if you have any questions or comments, please feel free to contact me. Thank you.